This is Charter Local Edition. I'm Brad Pomerance in the San Gabriel Valley today, and we are joined by Thomas Saenz. He is the President and General Counsel of MALDEF, which is the Mexican-American Legal Defense and Education Fund. You are going to be very busy this winter and fall as a result of the Supreme Court's decision to accept Texas versus United States. Tell us about that case, sir.
Texas versus United States is a case by the state of Texas and a number of other states challenging President Obama's exercise of his prosecutorial discretion to create a policy of deferred action for parents of Americans and to expand his existing policy of deferred action for childhood arrivals. Now, these are deferred action policies with respect to immigrants, recognizing that they are not enforcement priorities, are not likely, therefore, to be put into deportation or removal, inviting them to apply for deferred action, and if they receive deferred action, to also have the opportunity to obtain work authorization to be able to work with protection of the law.
Now, how is it that MALDEF is able to be so intricately involved? I would presume that the plaintiff, Texas, has lawyers and the defendant, the United States, has lawyers. How does MALDEF get involved?
So we moved to intervene in the case on behalf of 3 Texas mothers who are potentially eligible for deferred action for parents of Americans and who would therefore benefit from the president's exercise of prosecutorial discretion.
What does intervene mean?
It means that we asked the court to allow us to participate in the case as though we were a party, to join in defending the policy with the United States.
And is it common for courts to grant intervener status?
It is when there is an interest that may not be represented. So in this case, you have 2 powerful institutions, the United States government on one side and state governments on the other. You don't have the perspective of individual community members represented.
But as I understand it, it was an uphill battle to gain intervener status.
It was. Both of the parties opposed intervention, and that's not unusual.
Why?
They want to keep a case streamlined. They want to assert that they alone, in the case of the United States, can defend the policy appropriately. They want to ensure that the case is expeditiously decided, and there's often a concern that interveners will lengthen the case. That's not our approach in this case. We want this case resolved quickly.
So what happened? How is it that you were able to be deemed interveners?
So the trial court judge denied our intervention, but we appealed that denial to the Fifth Circuit Court of Appeals, and earlier this year they granted that appeal and ordered that we be intervened as parties.
And so does that mean the Supreme Court has to accept your status as an intervener, the U.S. Supreme Court?
So long as no one is contesting it, and so far no one is contesting it further, we are parties in the Supreme Court. Our clients are parties in the Supreme Court.
So what does that mean? Now that you're a party in this case, what's going to happen over the next few months?
Well, as you indicated, we've got a lot of work ahead of us. We have some good partners in a couple of pro bono law firms working with us to put together a merits brief, actually 2, an opening brief and then a reply brief, and all of this on an accelerated schedule because the Supreme Court's order indicates that it will hear the case this year, meaning we're looking at an oral argument before the justices in April and a decision probably before the end of June.
Were you surprised that the court decided to expedite this matter? It's not common, as I understand it, for courts to issue such an order.
I'm not surprised, in part because this is a preliminary injunction, which means we haven't really even gotten into the heavy-duty merits of the case yet. All that happened is that the judge got the case and a request by the state of Texas to stop President Obama from implementing his policies, and he issued that order. So it's at the beginnings of the case. We need to get it moving quickly. In addition, the case is just so important. There are millions of folks who could be affected by these new policies, and there's an eagerness to have them implemented.
So let me ask you about the merits. As I understand it, immigration is a question of federal law. So how is it that Texas is able to question the actions of the head of the federal government, the President of the United States?
Well, a central matter in the case right now is whether the state of Texas has that right. Does the state of Texas and the other states have standing to challenge the president's exercise of prosecutorial discretion through these policies? And the state of Texas argues that they do because they are harmed by these policies.
How is Texas harmed by allowing certain folks already living in Texas to gain at least temporary status?
So the state's argument, their central argument, is that they are required to provide driver's licenses to those who receive deferred action.
Are they required?
We believe they are required.
Okay.
And that their doing that imposes a cost, a monetary cost, because driver's licenses in Texas are subsidized by the state in their contention.
So this comes down to the DMV?
This major issue of standing does come down, in a sense, to the DMV. Now, the argument that we think is correct is that the state makes a decision to subsidize driver's licenses. It doesn't have to. So the fact that there is a harm from issuing driver's licenses is based on the state's own determination that it so values having people licensed that it provides a subsidy in issuing driver's licenses to everyone, including recipients of deferred action.
I want to ask about prosecutorial discretion, because in the news there's a lot of discussion about marijuana and either the use of medical marijuana, legalization of marijuana overall. And we know that the federal government still defines marijuana as a Schedule I drug, but yet we also know that the Obama administration, as well as the Congress now, has issued either regulations or statutory language which says we do not want the federal government to use its prosecutorial resources to actually charge folks with certain marijuana crimes. Is that not the same thing? We don't want the federal government to spend time on immigration actions for those whose parents, have kids that are citizens?
It basically is the same thing. We have long acknowledged and recognized through our laws and our practices that executives have to exercise discretion. There's simply not enough resources to go out and prosecute everyone for every crime that may be committed. So we make decisions, and those decisions in our government are made by the president. With respect to immigration, that's particularly true. Everyone acknowledges there are not the resources to go out and put into deportation the millions of folks who are here in undocumented status. That means we have to make priority choices. And every president has made priority choices.
So is Texas even challenging the priority choices?
No. In fact, what they're challenging is this particular exercise of discretion and whether, first of all, the president had to put out his policy for notice and comment by the public, a lengthy procedure under the Administrative Procedures Act, or could implement this policy as he has attempted to do. And second, they have argued that in exercising this particular discretion, he exceeded his authority.
So that is more of a substantive argument. He exceeded his authority in making a prosecutorial decision as to who to deport and who not to deport.
He exceeded his authority in this particular case given the numbers of folks involved and that they receive, in essence, some protection until there is a change in policy.
Prior presidents issued similar directives, I guess we'll call it, executive actions?
Yes, prior presidents have decided that certain groups of folks in particular categories are not priorities and should be granted deferred action. The whole reason the deferred action status exists is that other presidents have used it to cover certain classes of folks.
So what in Texas's mind is different about this deferred action announcement?
Well, it's always hard to explain the state of Texas, but I think that what they see as different here is the number of folks involved and the protection being extended to them.
So in our final moments, when do we expect a decision and what could that decision be?
Well, the decision would come before the end of the court's current term, which is at the end of June. We would expect, given the timing, would be really one of the last decisions they issue. And our hope is that they would lift the preliminary injunction and allow the president to implement his policy, exercise his prosecutorial discretion, to issue deferred action to parents of Americans, and to expand his program, his policy of deferred action for childhood arrivals.
His name is Thomas Saenz. He is the president and general counsel of MALDEF. My name is Brad Pomerance. You are watching Charter Local Edition.